Okay, hopefully that's recording. Right, well, welcome. This is the first King's Chambers seminar by Zoom that I've done. It's also the first, I'll call it Manchester Civil Law Masterclass. I'm sorry about the name Masterclass, it wasn't my idea. But what was an idea was born of a very pleasant lunch involving heads of chambers that do civil law in Manchester. And we were trying to explore ways in which we, could help each other, even though we're, as it were, competitors. And one way that came up in the discussion was to have masterclasses whereby those who, after many years, might pretend to be expert in a subject could share some of their knowledge with pupils and more junior tenants. So this is the first one. And Chris Kennedy, QC from 9 St John's Street, is going to give, hopefully, the second one, which is going to be on the subject of drafting counter schedules. So we don't know a date for that yet, because obviously because of the virus, we all had to reschedule everything. So my specialty is clinical negligence, and that's what I'm going to talk about today. It's at a fairly introductory level, but what I want to do is just talk about 10 key concepts of clinical negligence for those of you who are either brand new to it or are in the early stages of your career dealing with clinical negligence cases. And what is clinical negligence? I think of it sometimes as like a tree. It's a creature of common law predominantly. And so you have in the trunk, as it were, all the basic principles of common law, judge-made law, access to justice, fair trials, and so on, these sorts of principles. And then branching out of that, you have contract, administrative law, tort. We go up the tort branch and we get trespass and nuisance and negligence. And up the negligence branch, we then have employer's negligence, and professional negligence. And within professional negligence, we have clinical negligence. So clinical negligence is one small branch of the tree, but it's grown out of all the trunk and the main branches that I've talked about. And of course, it feeds off them as well. So you have to put it in context. Now, I'll be honest with you, one of the things that's expected of you, if you're going to be a barrister practicing in this area, when you sit down in a conference with medical experts who are professors of this and that, and your solicitor and your client, they sort of expect you to know what you're doing. And if you haven't got a medical background, which I haven't, some practitioners do, but most don't. Part of the trick, if you like, you have to pull off is that breezy self-confidence when you're dealing with medical terms and jargon, which you may not be familiar with. So this is the quiz part of today. So you can unmute for this purpose and these slides, okay? So I'm just going to test your knowledge and help you perhaps at the same time. So if you can see this slide, let's look at the bullet points in turn. So each row has something in common. So you can tell me what they've got in common and what these terms are. So what about the first row? What have they got in common?
Bones.
Yeah, bones, part of the body. Is anyone going to dare pronounce the first word?
Nope.
This is what clinical negligence really is about. So it's acetabulum. It's not acetabulum, as I've heard it pronounced and so on. So it's acetabulum. Where's your acetabulum?
Never heard of it, Nigel.
Well, I don't know if you can see me, but that's your acetabulum, and that's the top of your femur. So it's the hip, it's part of the hip joint. The scapula, so round here. Scaphoid, a common clinical negligence case is a missed scaphoid fracture in A&E. So that's in your hand, bone of the hand. And L4 is the fourth lumbar vertebra in your back. What about this? What about the second row? When would you see these abbreviations, do you think? Someone be brave. Okay, I'll tell you. So when you're looking at medical records, if someone goes, say, into A&E, or they've got an appointment at all with a hospital doctor, for example, these are classically the headings that you'd see. So PC means presenting complaint, and C/O means complains of. So it might be presenting complaint, headache, and vomiting. Okay? HPC is history of presenting complaint. So that might be 2 days ago, fell in park and hit head. Okay? OE, on examination. The triangle stands for diagnosis, and then the plan. So usually they say, for CT scan or something of that kind. Right, next. Someone have a go at this. ROM, etc. Where would you generally see those?
Examination.
An examination, well done. So ROM means? Well done. SLR?
Straight leg raising.
Oh, excellent. And plantars with a little up arrow?
I think please don't know that.
Up sort of, that's when, this is my hand, but when your feet, if you tickle up the bottom of your feet, it goes, as it were, go up like that. That might be a sign of neurological dysfunction. Next row, where do you see these abbreviations? Anyone? They're in blood tests. So hemoglobin, white cell count, C-reactive protein, alkaline phosphatase. That's to do with liver function. What about the next row? What do these have in common?
Types of doctors, junior
Types of doctors. So specialist registrar, first year, and sometimes you see RMO, resident medical officer. Next row.
Heart rate, blood pressure.
Yeah, temperature, respiratory rate. So these are vital signs. So often in an observation chart, you'll see these plotted by usually the nurses who have been observing the patient. What about the next row, EWS and so on?
Brain reaction to trauma.
You get EWS as an early warning score.
Glasgow coma score.
Glasgow coma score. What are APGAR? What's the APGAR?
I do not know.
That's a score for newborn babies. So it's a measure of their things like their skin color and so on. So it's a score out of 10, usually assessed at 1 minute of age, 5 minutes, and 10 minutes. So you might see in the note APGARs 9/1, 10/5. That means the APGAR score was 9, which is really good at 1 minute, 10 at 5 minutes. For a very poorly baby, you might see 3 at 5, 4 at 10, something like that. And so these are all scoring systems. And TNM is a commonly used scoring system for cancer, tumor, and then a small number indicating the size or stage of the tumor. N, meaning the number of nodes, lymph nodes that are involved. So that would indicate a nearby spread. And M, which is metastases. Easiest one of all, perhaps, the penultimate row.
4 days, 1 year, 3 months.
Yeah, so doctors tend to write 4 days or 1 week or 3 months in that fashion. And then the last one is to do with prescriptions. So you'll have antibiotics, 50 milligrams, BD twice a day. Analgesia, PRN, what does that mean? You might have seen it on one of your own prescriptions. So it's Latin, it's pro re nata, but it means as required. So you might be given pain relief medication to take as you need it. TDS is 3 times a day, QDS is 4 times a day. Mane means to take it in the morning, nocte at night. Okay, so you can mute again now while I plug my book. So I'm going to talk about 10 key principles, and I've taken them from a chapter of this book, what I wrote, which is an introduction for healthcare professionals and patients and lawyers to clinical negligence. And for those of you who don't know, I also write a blog about clinical negligence. So you can find a list on the blog of recent important cases. In fact, by now it goes back to about 2016, I think. And I try and keep a tab of cases in the High Court, Court of Appeal and Supreme Court, 2 this week, to do with clinical negligence, and put those on the blog. So that's a plug. And it's only £19.99, this book, which is remarkably good value. So let's look at the key principles. First one, the purpose of clinical negligence law is to compensate the injured or bereaved, not to punish those responsible for causing injury. Some of these, as I say, these are basic principles, but they're important. And what does it mean? It means if there's no injury, there's no claim. And that's something that I've been saying to clients for 30 years. And sometimes it's difficult for people to accept, because they say, what do you mean the doctor's got away with it? And you say, well, the system is compensatory, or words to that effect. And if you haven't suffered any injury, litigation is not the means by which you're going to get any satisfaction, because it's designed to provide compensation for the injury. It's not an inquiry into what happened. It's not a regulatory process or a disciplinary process. There are other processes than clinical negligence litigation for that. And very often causation is the difficult point in clinical negligence cases. So a difference between clinical negligence and, say, a road traffic accident is that 99 times out of 100, the person injured in a road traffic accident was fine to begin with. Well, let's say 9 times out of 10. Whereas 9 times out of 10 or 99 out of 100, the claimant in a clinical negligence action was injured already, because by definition, that's why they were seeking medical assistance. So in terms of compensating them, you're always looking in clinical negligence at the difference between what they would have been like, the outcome they would have had without the negligence, and the outcome as it now is with the negligence. Okay, so that's a difference and a significant feature of clinical negligence that you have to come to terms with. In terms of full compensation, you're therefore always looking out, as well as options such as PPOs or provisional damages, at life expectancy, because life expectancy is often a very important issue in clinical negligence litigation. Section 2.4 of the Law Reform Personal Injuries Act 1948, that's the act or the provision that says that the court shall disregard, for the purposes of assessing compensation for future expenses and losses, the fact that provision might be available within the NHS. So if someone says, I don't want the NHS to care for me in future treatment for my hip replacement, for example, because they're the ones who missed it when I was a baby, that I had dislocatable hips, or I want to have the choice of private treatment in the future, that act, that provision says the court should disregard the fact that the NHS may be able to provide that for free. Various organisations want that act to be repealed. The claimant always has to prove that they are likely to choose private care in the future or treatment rather than the NHS. Some, if you like, exceptions to the where there's no injury, there's no claim. Wrongful birth. So within clinical negligence, you have cases where as a result of medical negligence, it's alleged that a birth occurred that would not otherwise have occurred. In other words, the parents would have elected, if it weren't for the negligence, to have terminated the pregnancy. The child would not have been born. In those cases, so-called wrongful birth cases, the claimants are the parents, not the child who is born with injury, and it's only those who are parents of childs that have a disability that have a substantial claim in these cases. But the claim isn't the injured or disabled child's, it's the parent's claim. And the claim is an economic loss claim, it's not a personal injury claim. I could talk about wrongful birth for another hour, but we're not going to do that. There are other exceptions. So Human Rights Act, for example, it is possible, arising out of what you might normally term clinical negligence, particularly in a psychiatric setting, to claim damages under the Human Rights Act. And they're not strictly compensatory damages, they have a different flavour. And likewise, it is possible, although extremely rare, to claim aggravated or exemplary damages. So that's the first principle. The second, healthcare professionals owe their patients a duty to exercise reasonable care and skill in their management and treatment. So this is, again, a fairly basic principle. In other areas of tort or negligence law, you sometimes have to think quite hard about whether someone owed another a duty of care. I had a case once, was representing someone who had one of these sort of go-karts and went out with some friends for, you know, supposedly some fun, racing their go-karts around, and one of the friends suffered a serious injury and, amongst other things, sued my client who owned the go-kart in damages. And there were interesting questions about whether he owed her a duty of care. Doctor-patient relationship, there's usually no question about that. Doctors owe their patients a duty of care. But more interestingly, and sometimes you do get the question, who is the patient? So this really interesting recent case, I say recent, it went to the court. Originally, the defendant tried to strike it out, succeeded, went to the Court of Appeal, who decided that it shouldn't have been struck out. And it recently was decided, so it went back to the court for the substantive issue, and Mrs. Justice Yip recently decided it, this is ABC and St George's Healthcare, to say that the defendants were not liable. This was a case where a man had Huntington's disease, which is a very serious and progressive condition. He had killed his wife, the mother of the claimant, who was also his daughter, and he was made subject to a hospital order. So he was then diagnosed with this disease, and he made it plain he did not want his daughters to know about it, about his condition, even though it's a hereditary condition. The daughter later found out. She, in fact, was pregnant and later gave birth to a child, and said, I should have been told, and sued in negligence. Was she a patient of the hospital that was treating her father? So you do get these questions, and ultimately the judge decided that there could have been a duty of care in certain circumstances, but there was no breach of that duty in this case, and that so far as those who were actually treating her father, there was no duty of care to the daughter who was not their patient. You also get issues of secondary victims, people who have witnessed a horrifying event, and the whole law of secondary victimhood arose out of, heavily influenced by the Hillsborough disaster, and people who saw loved ones or saw a crowd in which their loved ones were, obviously in great distress and trauma. In a hospital setting, it's much more difficult to establish a duty to someone as a secondary victim, that is, someone who is not the patient of the doctor. Partly because the courts have said in a hospital setting, you should expect awful things to happen, and therefore it's different from, say, being in a crowd at a football match. So sometimes there are questions of whether the person is a patient, and sometimes there are questions of whether the defendant or the person responsible is, if not a doctor, a healthcare professional. So is an acupuncturist, or a recent case of mine, a chiropractor, are they healthcare professionals that are subject to the same principles that we're going to talk about later that apply to a doctor or a nurse? Do they apply to a chiropractor? Are they professionals? Or are they, as some my expert clearly thought in the case, quacks? And do they have a professional body that sets standards? If so, are those standards the standards that the court should apply? We'll come on to the Bolam test later. But issues like that do arise. There's a case called Shakur and Situ, which is useful in showing how the court, at least in that case, approached the question of the standard of care to be expected and the duty of care on someone who practiced alternative medicine. And finally, as well as the duty of care, you also have to think about a contractual duty in some cases. That doesn't apply to NHS cases, but of course there is private medicine, and looming large within that is cosmetic surgery, which is nearly always provided through the private sector, and questions of what the contract was between the patient and the clinic, or the patient and the surgeon, or indeed the surgeon and the clinic, what the contractual arrangements were and what the duties were under that contract can arise. So it's not all just negligence and breach of duty. But the basic takeaway point is in most cases, you're not going to be worried. It's obvious that a doctor owed a patient a duty of care. But you must also always think about this question. This is the third point. The extent of a healthcare professional's legal duty of care is to save their patients from avoidable harm attributable to their wrongful acts and omissions. So this is a short way of saying, always beware of the scope of the duty of care. So these are some cases you need to be up to speed with. There's a basic principle was stated by, and I'll come to it in a moment, by Lord Bridge and Caparo, a famous non-clinical negligence case called Samco, in which there's a hypothetical example of a mountaineer who goes to the GP, which I'll explain to you. And it's also quite interesting to look at Mrs. Justice Yip's recent decision in ABC and St. George, as well as everything else, but she concerns herself with the scope of the duty of care. So what a doctor may owe a patient a duty of care, but you must always ask, what is the scope of that duty? What was the extent of the duty of care? So that's the question that Lord Bridge in Caparo said always must be asked. What is the kind of damage from which A must take care to save B harmless? A being the doctor, B being the patient. I mentioned the mountaineer's knee. It was a hypothetical example given by Lord Hoffman in this Samco case. So the mountaineer is due to go on an expedition to the Alps. He's worried that he'll be fit enough to undertake the expedition. He goes to his GP. The GP gives him a clean bill of health, negligently giving the mountaineer's knee only a cursory examination. The mountaineer goes on his expedition to the Alps. He's halfway up a mountain when he's crushed by an avalanche. Is the doctor liable for the injuries caused to the mountaineer in the avalanche? Okay. And Lord Hoffman said, no, it wasn't within the scope of the duty of care of the doctor to advise about the risks of avalanches. Now, people struggle with this, but this was the analysis of Lord Hoffman, that where a person is under a duty to take reasonable care to provide information on which someone else would decide on a course of action, i.e. your knee is fine, that's information that the mountaineer then took away and fed into his decision, which had other factors involved in it, the weather conditions, the equipment he needed to take, who he was climbing with, which route he was going to take, all of these things, the risks of avalanches in the forecast. So the doctor was just giving information to the patient on which the patient made a decision for themselves. And if negligent, the doctor is not responsible for everything that then happens, but only for the foreseeable consequences of the information being wrong. In this other non-clinical negligence case, Lord Sumption said that principle applies even if the doctor knows that the patient is going to act on the information in a certain way. So when is a doctor giving advice and when is a doctor giving information? In certain cases, you really need to think hard about that to determine what the extent of the doctor's duty of care is. In advice cases, generally, and again, the case here, Manchester Building Society, is not a clinical negligence case, so I've adapted it to medical negligence. In an advice case, the doctor is responsible for guiding the whole decision-making process. They effectively make the decisions for the patient. In an information case, all they're doing is giving information to the patient, and the patient then makes a decision for themselves. And the doctor is not responsible for all the foreseeable consequences of everything that happens next or everything that goes wrong. So people tend to wrongly think of causation and clinical negligence cases as a bit like a row of dominoes. I hope you can see all those four. In other words, you might say the doctor gave negligent information to the mountaineer. As a result of that, the mountaineer made a decision to go on the expedition. As a result of that decision, he climbed a mountain. As a result of climbing a mountain, he was crushed in the avalanche. So didn't the doctor owed the patient a duty of care? The doctor was negligent, and as a result of that negligence, these things happened, and the mountaineer was injured or killed in the avalanche. So why is the doctor not negligent? So the better way of thinking about these cases is this, that the patient suffers an injury. Is that the kind of injury which the doctor, and I'm using doctor as short form for all healthcare professionals, that the doctor owed a duty of care to the patient to protect them from? Did the doctor either have a duty to give information to the patient to allow them to protect themselves against that injury, or did the doctor have a duty to actually take action to prevent the injury, as opposed to just giving information about it? Did the doctor breach their duty of care? And then you ask, but for that breach, would the injury have occurred? Okay, so that last question does not come at the beginning, as it were. So if we apply that to the mountaineer, the patient suffered an injury. Well, what was the injury? It was being crushed in the avalanche. Did the doctor have a duty to give information to the patient to allow the patient to protect themselves against being crushed in an avalanche? Well, when you ask that question, it seems more obvious. The answer is no. Did the doctor have a duty to take over the decision-making for the patient or to protect them against avalanches, to take direct action themselves? Well, no. Did the doctor breach their duty? Well, it's no longer applicable because it wasn't within the injury the injury concerned, that being crushed in the avalanche, wasn't within the scope of the doctor's duty of care. As it happens, the doctor was negligent, but it wasn't in breach of that relevant duty. And so neither is it applicable to consider causation. Okay, so principle 4, the law requires the healthcare professional to exercise a reasonable standard of skill and care. So this is a warning to you. When you get expert reports, however eminent the experts are, sometimes, and then usually not qualified lawyers, 1 or 2 are, but they sometimes haven't had the training or don't have the knowledge of how the law works. And so you see expressions like, in this case, the care afforded to the patient or to the claimant was suboptimal. It was below par. It was less than desirable. Those are pretty useless phrases to you as a lawyer. And I'll go into that in a little bit more detail. But the standard is the same in all negligence cases. It's to exercise reasonable care. We'll look in the next principle at what that means in a medical context. But it's always just reasonable care. Suboptimal care is everything below being the best. It's everything below gold standard, isn't it? Well, that's not negligent. You're going to have to be aware, in many cases, of guidelines and protocols. Now, they are not the law, but nonetheless, they very often set a standard or an acceptable standard for healthcare professionals to follow. So look out for any national guidelines, and there are plenty of them. nice guidelines, and sometimes within the trust in which the doctor was working, there will be protocols in place. So you may need to say, is there a trust protocol for the use of antibiotics after a leg amputation operation or something of that kind? So that it may be that you can judge what was done or was not done in a particular case by reference to a local standard. And very often, of course, in clinical negligence, there are no absolutes. You're always, as a doctor, and you have to be aware of this as the lawyer dealing with these cases, balancing risks and benefits. So there's very rarely that everything points one way. A doctor is having to balance whether they do this investigation or not. And that's something you have to be aware of when judging the standard of care. So the fifth principle is this: if a healthcare professional acts in accordance with the practice of a reasonable body of relevant professional opinion, they're not negligent. So this is the well-known Bolam test. This is the most basic case of all. You have to know this. Just breaking it down a little bit, you're looking at what is a responsible body of opinion. And what is a body of opinion may vary from case to case. So if you're dealing with a GP who is presented with a child with a severe sudden onset headache, well, there's a lot of GPs who deal with that sort of problem. There's probably guidance available. It'll be pretty clear what a reasonable body of opinion would think. Of course, the whole point of the Bolam principle is that there may be more than one reasonable body. If you're dealing with a very innovative brain surgery technique, there may be only 5 neurosurgeons in the country who have ever done it or practiced it. So you have to be aware that a reasonable body might be a very small number of practitioners. What is the practice that is being talked about? Well, again, in most cases, you'll be dealing with the practice of examination, of diagnosis, of deciding upon treatment, and of implementing that treatment. In some cases, the courts have wondered whether the Bolam test should apply to other aspects of medical practice, such as histopathology. So looking at a sample under a slide and saying it has cancer in it, the temptation is to think that's either correct or incorrect. And if they've got it wrong, isn't that negligence? And the courts have not gone that far. They still apply a Bolam test, I think, in those cases. And actually, when you talk to histopathologists, they may say in certain cases, actually, there would be a range of reasonable opinion as to whether that showed a malignancy or not. What's a relevant body? The body has to be relevant. So if you're dealing with an accusation that a GP has been negligent, you don't want an orthopedic surgeon to tell you whether the GP has been negligent. You want a GP. So the body in question, it has to be relevant. And what you need is an expert who has that relevant expertise to say what a body of general practitioners would consider reasonable. It also has to be relevant in terms of time. So if you're dealing with an obstetric case where the child is now 18 years old and was born in 2002, you need to know what the standards of care were at the time in 2002. It's no good knowing what they are in 2020 and what a reasonable body would do now. You need to know what they would have done in 2002. So no retrospectoscopes. And the standard of care is also referable to the role which the medical practitioner was fulfilling at the time. The important point is this: they might not have the qualifications of, say, a consultant. So it might be a specialist registrar or a senior house officer, as they used to be called, so a more junior doctor. But if they're fulfilling a role that is a role properly fulfilled by a consultant, they have to meet the standards of the consultant. Okay, so the standard is set not by the qualifications of the individual involved or their own experience. It doesn't let someone off the hook that it's their first ward round. They have to fulfill the standard that is set by the role. And a useful case on that, as well as the recent well-known case of Darnley, really, which dealt with a receptionist, is FB and Princess Alexandra Hospital. So principle 6, even if a practice is considered proper by a recognised body of professional opinion, the court should also consider whether it's logical, rational and reasonable. Is another way I think of saying that it's not a reasonable body of opinion if the opinion they have and hold is irrational or illogical. So the court is enjoined, and the case is belitho, the authority for it, the court is enjoined to consider and scrutinise whether the practice that a body of orthopaedic surgeons, for example, consider to be reasonable is actually logical. Does it bear scrutiny? Is it rational? So in some, but only a few cases, the court will, as it were, override what is common practice or the practice of a group of otherwise competent practitioners and say their practice is irrational and therefore it's not a reasonable or responsible body and it's negligent. But it's rare. The courts are very reticent, understandably, to take that position. Number 7, when obtaining a patient's consent to treatment, a healthcare professional has to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatment. So this is the principle that was articulated in Montgomery and Lanarkshire Health Board, which is now the case on consent. And if you haven't listened to the podcast, I did an interview with Nadine Montgomery, who is the mother of the child involved in the case, and you can hear what she has to say about her journey through litigation in that. It's on King's Chamber's website. But the principle is that the Bolam test does not apply to issues of consent to treatment. So in Montgomery and Lanarkshire, the court said a doctor has a duty not to act in accordance with a responsible body of medical opinion, but to provide the advice about risks that is material to that patient. Now, there's a gloss on that from Duce and Worcestershire, which is a Court of Appeal, a more recent Court of Appeal decision, where the Court of Appeal said, well, there are 2 stages to this. The first stage is whether the medical practitioner concerned ought to have known about the risks of treatment. So that seems to me to be a Bolam test. What ought the practitioner to have known about the risks of the proposed procedure? But once they know or ought to know of those risks, then if they're material to the patient's decision, they have to be communicated to the patient. And the same principle appears to apply, and there's a first instance decision called Bailey, which is in the handouts that I'll send to you, seems to apply also to questions of alternative or variant treatments. I have been asked by medics, well, what if I know there's some treatment that's only available in California? Do I have a duty to tell the patient about that? And the fact is, there might be in certain circumstances, but it's only, there is a Bolam test as to whether a doctor would consider alternative treatment as both feasible and perhaps reasonable in the circumstances. So there is it's not as if you have to list every quack therapy that might be out there when advising a patient as to the alternatives. And Thefaut and Johnston was an example where I think it was a neurosurgeon, was found negligent not to have advised the patient of a 5% risk that their back condition might be exacerbated by surgery. In other cases, Hassel and Hillingdon, the High Court found that a doctor had been negligent not to advise a patient of a 1 in 1,000 risk. The same judge in another case found it hadn't been negligent to have advised that patient of a 1 in 1,000 risk. And what that shows is that you can't reduce the materiality of risk to a bare statistic. All depends on the context and all depends on the patient involved. The timing of consent is also important. Just signing a consent form is not giving consent necessarily, it's evidence that the patient gave consent. So in cases where a patient, and this has happened, has literally been handed a consent form on the trolley as they're being wheeled into theatre for their surgery, that isn't giving consent. That's not informed consent. Okay. The next principle, if I can get it up. NHS Trusts are liable for the negligent acts and omissions of their employees and other staff concerning the management and treatment of patients. So vicarious liability. And this week, the Supreme Court's been considering vicarious liability for an organisation, for a doctor. That's Barclays Bank and various claimants, which was decided by the Supreme Court this week. In that case, Barclays Bank engaged a doctor to examine employees or applicants for employment, and he indecently assaulted a number of them. And the Court of Appeal said that Barclays Bank were vicariously liable for that doctor. Supreme Court said, no, they're not. In the vast majority of cases that you get involved in, it's not really an issue. It is accepted that an NHS trust is vicariously liable, for the negligent acts and omissions of all the medical and surgical personnel, etc., who work there. So I usually start a pleading by saying, the defendant is responsible for the management and control of Smith Street Hospital and for the acts and omissions of the medical, surgical and other personnel at the hospital concerning the care, treatment and management of patients, something to that. And it's never been challenged. So trusts are vicariously liable for the acts and omissions of the doctors and nurses, etc. Sometimes a hospital will contract out services and to a private company. And surprisingly, there is no absolutely definitive decision authority on whether they can delegate those duties and avoid liability, or whether that sort of thing is a non-delegable duty. There is the case of Farage and King's Healthcare, where the court did consider it in a rather sort of unusual set of circumstances. And if you look at the case of Cassidy, for example, it looks very much like the court would find that most of the core duties of a hospital towards a patient are not delegable. Woodland, of course, is the swimming pool case that you may be familiar with, but you can see how you could apply the principles in Woodland to say that a hospital has a non-delegable duty to its patients. And so if it contracted out a service that was then negligently performed, it might be difficult for the trust to wriggle off the hook in those circumstances. Number 9, liability only arises where negligence causes or materially contributes to injury or death. As I said earlier, causation is often one of the most difficult issues in a clinical negligence case. You can start with a basic but-for proposition. What would have happened but for the negligence? And medically, that can be very, very difficult to determine, because as I said earlier, the patient is ill in the first place. And so you have to predict what would have happened if they'd been treated non-negligently. Belitho is also authority for the woulda, shoulda principle, which is that if but for some negligence, a patient would then have been treated in a certain way. The first question is, what would have happened? So would that patient have been given antibiotics, for example, to cure their infection if they'd been referred to hospital? And if the defendant says, no, they wouldn't, because Dr. Smith here says he never gives antibiotics to someone with that particular condition, and so they wouldn't have been cured, the court will go on to consider, well, would Dr. Smith have been negligent in not giving that treatment? So you would plead a case on this basis, but for the negligence of the defendant, the claimant would or should have undergone an MRI scan, or would or should have been given antibiotics, which would then have cured their infection. Wiltshire is authority for the obvious principle that if there if there is a series of possible causes for the injury that was suffered by the claimant, one of which is a negligent cause, the claimant can't just say, well, there are 5 possible causes and the injury occurred, which is just the sort of injury you'd expect from the negligence. The claimant has to prove on the balance of probabilities that it was the negligent cause that caused the injury. In Hodson, that's authority for if the claimant would have probably come to the same harm in any event, there's no causation. Chester and Afshar, I'm tempted to say, is a unique decision which is never now going to be repeated. But for those of you who don't know it, the patient was due to or was advised, recommended spinal surgery. There was a small but real risk that she could suffer from paralysis as a result of that. And she wasn't warned of the risk. She went ahead with the surgery and suffered the injury. And she said, if I'd been warned of the risk, she could have said, if I'd been warned of the risk, I would not have gone ahead with the surgery. Well, then you're in the realms of, well, what would have been the outcome for her? Because if she needed this surgery, presumably she was going to deteriorate anyway. But she didn't say that. She said, I would have gone away and thought about it and maybe got a second opinion. So the defendant said, well, you haven't proved that you would have avoided the operation and therefore avoided the injury. But the House of Lords, as then was, said, no, there's a principle of autonomy here. The defendant is liable, even though the most she could say is, I would have gone away and thought about it. That decision is being strongly doubted since, including by the Court of Appeal in Duce, where Lord Justice Leggett poured lots of cold water over it. But you need to know about it. Bailey and MOD is about material contribution. So if the state of medical science is such that it can't be said that but for the negligence, the injury would either have been avoided or would have occurred anyway. But the experts say and persuade the court that the negligence made a material contribution to the injury, that is a contribution that's more than negligible, then the claimant will succeed, the claimant will win. And that was articulated, I thought, very well, but in a very short judgment in Williams and Bermuda, which is a Privy Council case. So the Privy Council said, you've got to look at some injuries, and in that case, that injury, as a result of a process. So if you have a process of infection, for example, which then leads to brain damage, and there's a period of time whilst that infection is ongoing and building, where there was negligent delay in administering treatment for it, and you can't say actually without that delay they would or would not have suffered the brain damage, but you can say that that period of delay made more than a negligible contribution to the brain injury, then the defendant is liable. So that's a key case on material contribution. Sometimes clinical negligence acts as or is alleged to have acted as an intervening cause, but it's only where the clinical negligence has been very significant, almost gross negligence, that it acts as an intervening cause between, say, a leg injury in a road traffic accident and the amputation of that leg. So in Webb and Barclays Bank, the doctors had been negligent in the way they treated the leg, but it didn't act as an intervening cause, breaking the chain of causation between the original tortfeasor and the amputation. And in Wright and Cambridge Medical Group, the GP had been negligent in delaying, I think it was, referral to the hospital, but the hospital had then been negligent when it treated the patient. And the doctor said, that lets me off the hook. And the court said, no, it doesn't. And the last 10th principle, a negligently injured claimant's entitlement compensation may be reduced or extinguished by their own fault, dishonesty, or criminality. So some of these principles apply, of course, to all kinds of negligence case, but it's quite interesting. Contributory negligence traditionally has been hardly ever argued by defendants in clinical negligence, but it's much more common now. The case of Pigeon and Doncaster was a case of a woman who had negligently had a smear test, cervical smear test, and it was negligently reported as all clear. she should have been asked to come back for further testing. So there was negligence, and there's obvious causation there as well. But she then subsequently failed to attend later smear tests in the years afterwards, and she was found to have been contributory negligent and reduced her damages significantly below what they would otherwise have been. Look out for illegality. So if someone is negligently treated for a psychiatric condition, they then go out and murder someone, there is a question about whether their incarceration thereafter and any damages they may claim is due to illegality rather than the original negligence. And do look out for dishonesty, which the courts are, generally much more prone to look at these days. And an example of that in a clinical negligence context is Razumas and the Ministry of Justice. The defendant's name, it was a clinical negligence case, but the defendant's identity giving a clue to the criminality of the claimant in that case, who was found, amongst many other things, to have been fundamentally dishonest when bringing their claim. Just on contributory negligence, I can tell you I've had cases where people have attempted suicide because of a psychiatric condition, but have suffered very severe injury rather than actually taking their own lives, where the defendant has alleged contributory negligence. So contributory negligence against someone who blew half their face off with a shotgun while they were in a psychiatric state, someone who jumped off a hospital roof in a psychiatric state. Nonetheless, the NHS claimed that they had contributed to their own injuries. In those cases, and there is some authority for it, which is called Reeves and Metropolitan Police Commissioner, there is authority to support that. You need to ask, in all those cases, did the claimant have the capacity to judge their own interests in terms of health and welfare? And if they didn't have mental capacity, that's a good start for defeating an allegation of contributory negligence. So just a few do's and don'ts, and then I'll turn off the recording and happy to take any questions. I haven't done this as we've gone along so that we could have a clean recording of the seminar. So I just say this: for do's, learn how to pronounce acetabulum and similar. You can always use Google. There are even some pages on Google where you can actually hear the pronunciation of words like drugs names with 12 syllables. So have a go at that. When you're in conference, you just have to have the confidence to take a lead. It's you who would be presenting the case at trial. I say in the slide, no, you won't, because I'm afraid trials are very, very rare in clinical negligence. But you have to prepare a case as if it's going to go to trial. You're the one who's going to be explaining it to a judge. So you take a lead. You got to know what you need to know. Okay, so obviously when you're dealing with professors of surgery and so on, they have a natural inclination to want to take a lead in any meeting, especially the men, I'm tempted to say. But you need to take a lead, and it's you who needs to know the key legal points that you would have to have in mind when you present it at trial. Keep it simple, stupid. So if you don't understand something, you ask. And there'll be a lot of complications in a lot of clinical negligence cases, a lot of technicalities, a lot of medical complications. Try to distill it into, was there a duty of care? Was there a breach of that duty? But for that breach, what would have happened? Was there a material contribution? Keep those things in mind and try to distill the evidence to meet those key points that you have to prove. So try in your own mind to keep it simple. Don't get too distracted in all the detail that will inevitably be there. So I prefer to see a 10 or 15 page particulars of claim where you've referred to the essential information in the medical records than 100-page particulars of claim that's thrown in everything from the records. One of your jobs is to try and keep it simple. And one of the reasons is that eventually it'll be seen by a judge who highly likely will not have any medical background themselves. So you're going to have to explain it to a judge who's another lay person in these in this context. Keep it consistent. So this is difficult because experts have to present a case to the court. They're reporting to the court, and their opinion has to be obviously honest. But you have to look out for inconsistencies. Always be alert to that. Are there inconsistencies on the facts? So is the expert basing their opinion on a consistent set of facts, or that is consistent with what everyone else in the case is taking to be the facts? So keep it consistent as well. I say worry, part of our job is to worry what can go wrong in a case. So look out for the traps ahead, and you have to be constantly worrying about what can go wrong whilst trying to maintain the confidence of your client and solicitor that it's all going to go well. So don't bluff. It is tempting, surrounded by medical experts and the client and the solicitor, when you don't understand it, to think, I'm the only one here who doesn't understand this. I can't ask. It would be embarrassing to ask because I'm going to make a fool of myself. Well, I adopted a practice of saying quite early on in a conference to the client, please ask questions yourselves and don't worry about asking a stupid question, because I've made a career out of asking stupid questions. It may not be a stupid question. It may be a vital question. It's much better not to bluff and pretend you know everything that's going on. Much better to just be open about it and ask the question, okay? Bluffing will end in disaster. So don't be embarrassed to ask questions and continue asking them until you understand. If you don't understand, it's probably, because you're all intelligent people, it's probably because the expert hasn't explained it very well. And if they can't explain it very well to you, they're not going to be able to explain it very well to the judge at court. So keep asking the questions if you don't understand. Don't be afraid to do so. And don't lose your objectivity. A lot of clinical negligence cases, they're to do with, the essential points of life from birth to death. And they can be very emotional. And you can feel very, very sorry for your clients if you're for a claimant, and very sorry for the doctors if you're for a defendant, because very often they are competent and hardworking people and diligent who may have made a mistake on one occasion, or which may have terrible consequences, way beyond the sorts of consequences that we as lawyers are used to dealing with if things go wrong or we make a mistake. Or they may be part of a system that's let them down and they may feel they're being made a scapegoat. So it's on both sides. You can fall into the trap of wanting to fight a case because you feel really sorry for a claimant or for a defendant, but don't lose your objectivity. Okay, that's important to hold on to that. Okay, so that's just about an hour. So I'll stop screen share so I can see you all again, and I'll stop record, I think. How do I stop record?